Mr. Brooks, I was provided with information that your test result was hand-delivered to you, folded. Did you receive that?
I was made aware of I didn't look at it yet. So.
Do you have it with you?
It is. It's in my paperwork somewhere.
All right, I need you to locate it and open it up, please.
May I ask the reason why they would be?
Mr. Brooks, you raised this issue yourself, and I'd like to know the result.
I would too, but I was kind of in the middle of preparing for my defense, so
Mr. Brooks, find the piece of paper and open it up and read it, please.
Your Honor, I don't consent to being talked to in that fashion.
Your lack of consent is noted for the record. Please find the piece of paper, open it up, and please read it.
I will not consent to that, Your Honor. Where do I agree to that, Your Honor? I do not.
A few moments later.
It's my understanding there was some type of situation or altercation between Mr. Brooks and the deputies. Ultimately, though, I think he was taken into the bullpen. He was brought back out, but it was very clear to me that he was upset. I think understandably so, but I needed to make a record of what was being done, including that I have obtained the test result, so there's an accurate record in this case related to the motion that was raised previously by Mr. Brooks, but I can confirm that the test result for COVID-19 was negative.
Hello and welcome back to Mushmouth Joe. In my previous video, Judge Darrell mentioned that jury selection would take place on October 3rd of 2022. But before that day came, Darrell Brooks decided he wanted to represent himself. So the court spent 2 extra days at the end of September arguing with that degenerate scumbag to determine whether or not he should be allowed to be his own attorney. It was noticeably frustrating and tedious for Judge Darrell. But after that motion was finally granted, the court reassembled on October 3rd of 2022 just as originally planned. And they began the process of jury selection, which unfortunately was not live streamed at all. But I do have a short clip from October 4th of 2022, which was the second day of jury selection. And like I said, this clip is very short, it's under 20 minutes long. And I'm not even sure which part of the day on October 4th this footage comes from. But this is the only clip that I can find from those 2 days.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing
being
the line,
removed from the courtroom for continued interruptions.
I
want you
consent
here.
to that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. It is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. You have been provided with the copy of SCR Chapter 62 that lists the responsibilities that myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front
Mr.
of
Brooks,
me.
I'm going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild manner tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, for these proceedings. You have demonstrated in the short, not even 30 minutes that we've been on the record, that you will continue to disrupt. I am going to have the jurors brought in. Again, it is my sincere hope that you follow these simple and basic rules, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent,
We have the jurors here?
and I will not agree to anything.
Not yet, okay.
So again,
Your Honor, just from the
with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks.
in her possession?
No one's going to be answering these questions, okay? I'm not requiring an estate to do that. I'm advising you to stop asking those questions.
request
It will
the-
be considered he's interrupted.
I
Take him to the
request
next
the title
courtroom.
name.
I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move the court again.
So I'm really glad we got to see this bonus footage of Deputy Stoneface. I kind of like that guy. He reminds me of Officer Tackleberry from the Police Academy movies. But anyway, Brooks has been removed from the courtroom again because he can't keep his stupid mouth shut.
Currently, you are not muted. All right, Mr. Brooks? All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. And even though I made a decision not to answer questions, he keeps asking those. From my perspective, they are questions that any sovereign or sovereign citizen tends to ask regarding my name, my oath, jurisdiction, things of that nature. This court, of course, has authority from the Constitution of the state of Wisconsin, the statutes. I've been duly elected twice now by the citizens of Waukesha County to preside over criminal and other cases in the courts of Waukesha County. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that, but from my perspective, they are not issues that need to be debated. He raises these issues really just by simple statements. He has never filed an appropriate motion. Motions are governed by state law. Written motions require that the specific relief be requested, that the motion be based on law and fact. I've never gotten anything even close to that from Mr. Brooks. Even if I were to accept an oral motion, which can be proper at times, he has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is again once is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I am cognizant that the one limitation is the cameras do not pick up the jurors when they sit. There may be, depending on the angle on the witness stand, a few jurors that would get captured, but of course he cannot see those. He's able to hear them, of course. I will instruct the bailiffs over there to give him a pad of paper if he doesn't have one already. I know he had some documents and some things in front of him. At one point, I saw him sort of do a sweeping motion, and things seemed to go flying. I'll get some verification of that from the bailiffs who are over there through the bailiff that is in my courtroom. But he will at least be given a notepad, a writing utensil. He is advised that should he want to raise a strike for cause of any juror, my procedure is to address that at the end. Certainly if something comes up before that and he wishes to do that under the law, he can simply write on the pad of paper he has cause, hold it up, and I'll make a determination if I should excuse the jury and then take up that decision. I'm probably not going to do that with frequency. He would need to further not only do that, but write on a piece of paper the juror number, the basis for that request before I would require the jurors to be excused to take it up. But that's the procedure that this court will follow. Just like I did yesterday, after I get through all of the questions, I will ask the parties if there is a request for any individual questioning of jurors, meaning outside the presence of other jurors. I would need to know again, what juror number, what question they need to be questioned about, whether that be a numbered question from the questionnaire or a question that was asked in court. Parties will also be given an opportunity to ask appropriate follow-up questions. Once that opportunity is concluded, I then have a few concluding questions, and then ultimately will excuse the jurors to take up the issue of strikes for cause. I've been advised that Mr. Brooks did throw some items on the floor, but he does have his paperwork and a pen.
Your Honor.
Go ahead.
I just want to make sure that we put on the record that it has been verified that Mr. Brooks can hear this court.
Do that, yeah.
Also that I believe I had heard that the juror questionnaires for the next set of jurors coming in have been provided to Mr. Brooks.
Thank you for that reminder. He has been provided with 2 additional binders. He probably doesn't even have the first one anymore because the first binder only went to juror number 41. He does? He still has it? Okay, so he has that binder. He has 2 additional binders, which are separated. I believe it's 42 to 70 and then 71 to 100 something. But it is the balance of the jurors who had been instructed to come on day 1. This is the jurors who were not questioned yesterday. It's not even all of them who will be coming in because of the physical limitations in this courtroom. We'll bring in 41. So he has been provided with those binders. Were we able to verify? We were able to verify the audio is working. The video is working, just like we can see him, he can see us. For those of you who are in the courtroom, what he would be seeing on the monitors would be that 4 square as well, because it is through the Zoom, he would have his picture as well. So he would see the double image, if you will. I should also make a record that there are a number of individuals on my Zoom as well. There was a request by the state to allow victims under the statute and Constitution to be present by Zoom for jury selection due to the court not streaming jury selection. I believe I also have Attorney Anna Keys also watching as well, along with at least one actually I think I see 2 victim witness workers. So I have a lot of screens up here, a lot of boxes on my screen. So I believe the state has complied with victim rights. Would you please confirm that?
We have.
Did I overlook anything you asked me to cover?
Your Honor, the only other thing, and I think the court somewhat made a record by your findings, but I know that the defendant made 2 motions to dismiss for judicial misconduct. Again, I'd ask the court to summarily deny those motions based upon lack of merit, and he didn't provide any support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal. While that's really not something I would need to address because nothing's been filed as it relates to a request for an appeal, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. All right, anything else then before the jurors are brought in?
No, Your Honor, thank you.
I will, just like I did yesterday, advise the jurors that Mr. Brooks is appearing from a remote location, and that should not influence their verdict in any way. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise any issues with the court, he is advised to write that down on paper. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me forthwith so that I can raise any issues of merit. All right, with that then, we will begin the jury selection process, and so we can go ahead and bring them in.
And that's all the footage we're going to get out of that one. And if I read the details of the jury selection correctly, I'd say it was these 2 days where they perfected the process of removing Brooks from the courtroom. And I think it was Sue Opper who said it would take about a week to select the jury. But because Brooks had to be repeatedly removed from the courtroom, they were able to get it done in 2 days. And I guess since the prosecution really had no opposition to speak of, it really sped the process up. And you know that had to make Brooks very angry. Instead of slowing down this process, his shenanigans have actually made it go faster. So when the court resumed on the next day, which was October 5th, Darrell Brooks suddenly has a brand new strategy. Not to mention the fact that he's also extremely dehydrated, and his back seems to be stuck in this position, bent over the table. And my assumption on that is, his cellmate must have had a great time last night.
State versus Brooks, case number 21, CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper,
Leslie Basie and Zach Witchow, all appearing for the state of Wisconsin.
Sir, state your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. Also, Your Honor, I would like to make an offer for my appeal, if I may.
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody. And it's my understanding, Mr. Brooks, that you were offered to appear in the suit, but chose to come to court in jail attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
Consent or identify by the name that you stated earlier. I want the record to reflect that, if I may.
What is your name? Brooks.
The record will reflect. Thank you. All right, I know there was some filings, and I want to make sure the parties have copies of everything. Mr. Brooks, I know there was an inmate communication form filed, I believe earlier this morning, requesting 6 subpoenas as soon as possible. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand delivered. Did you receive those, sir?
No, I did not.
We'll provide additional copies. Again, it's my understanding those were hand delivered to the jail, and that the jail took care of that in the event that that latter part did not take place. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies. And when that is done and those are handed to you, I'll make a record of that.
Will we address the inmate communication form I sent about
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
Well,
I'm not seeing it in the record yet, so I did a F5, so it'll refresh.
So the prosecution will receive a copy?
I believe one was printed now for them. It is in the record, and then I'm going to print off something as well. I don't know if it was already.
Your Honor, I respectfully would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go any further.
Preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well. And I want to confirm with Attorney Opper that you have now received a copy of that inmate communication form.
Yes, I have one in front of me, Judge. It's dated today's date, October 5, 2022.
Yes, dated today because I just learned of the protocol that I would be on as of today.
All right, I'm going to provide a document to the parties. It's a 5-page document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court, after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19.
Wanted to accept that if I don't believe that it's...
It will be placed on your table, but I will be referring to that today, so it's been given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was
Respectfully
provided.
object. I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. Because I have not consented to or agreed to accept any paperwork that.
Sir, it's been
It's not-
provided to you. It's
So are you
something I'm going to
making-
consider. You don't want
Are
to
you
read
making-
it.
are
You want to
you making a
disregard it. That's
judicial-
your choice.
Are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir. Again, I did I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified with court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom. Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically.
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication form.
It could be verified because I was told when I was brought down here that everybody knew that I was on a COVID protocol. That's why everybody
Because you advised us.
That's why, no, because the jail advised them. That's why they had to wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the jail confirmed. That is very easy information to obtain.
Sir, I
Just-
have
just like-
an attorney for the
Excuse me, Your
county
Honor.
here
I
who
don't-
will
I don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due to
I don't-
HIPAA
I don't want you to
requirements.
think I'm arguing.
So I'm not
But I-
arguing it with you, sir,
I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here
don't
we go.
consent or agree to being cut off right when I'm trying
All right,
to
I'm just
provide
going to
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain. And I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. Like I said, I've never had this happen.
Clarify that. That was a pretty ambiguous question. So you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can, because they control the movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the moment.
It's not, but I'm saying, how can I tell you, how can I answer what you're asking me? It doesn't make sense. We all understand that the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk about inmate movement at the moment. What I'm asking you is, do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know what type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's impossible for you.
If I can make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results for the test I already took?
But you're telling me you're scared? You're
Yes,
fearful,
I am.
But you don't want to take a test that might tell you today?
I took the test that he gave me.
And
if
you're
he
telling me
felt-
that test result won't be available to you until at least Friday?
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be
Sorry,
placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor.
Okay.
I have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be what we call rapid tests, or what are called rapid tests, that are available. And then there's these other tests which take a few days. Again, I'm not a scientist, but I think the general belief would be sometimes the rapid tests are accurate, sometimes they're not. Sometimes people test negative when they're really positive. It just kind of depends on the circumstances. But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, etc. I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I was
work
told with-
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
Well,
I had
did
a
you
lieutenant.
report symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no, anybody knows their body. I said, this got to be something more, because I'm really, I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said, okay, now I need to put the medical sick
When did
call
you
slip in.
report these symptoms to the medical people, or to even just a correctional officer?
A few days ago. Over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired. Usually I don't just jump the gun and say something's wrong, because it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
And was it after that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What other symptoms are you reporting at this time?
That was it so far, just the fatigue and the loss of taste, which is the reason why I was told that I had to take the test, which I was told at that time also that the earliest my results would be back would be Friday.
And you said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do. The nurse was very clear in what he was telling me when he told me how to test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a very specific question to
I
you,
was
sir.
asking them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the test. This is what I was told. And after he told me that, I said, okay, fine, just do the test and I'll just sit on the protocol, because at first when he told me, you're going to have to be on a protocol where you're isolated. I said, okay, fine, just do the test. I'd rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back, and I would be placed on a protocol which is called isolation, where I'm not allowed out of my cell.
So do you think he actually believes that she's buying this crap? She knows he's lying, and so does the prosecution.
Anything else, sir, you think I need to know about this issue as I consider your request?
No, at this time, I'm just telling you what I know. Multiple officers were there. They can tell you the same thing that I'm telling you now. Like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is.
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information, because like I said, I'm limited in the pod that I'm in. I have no interaction with any other inmates, and my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information. I know, sir, what I've provided to you is generally for employees. I fully recognize that the jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols, and despite you reporting fatigue, I know, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he is.
How could that even?
Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object. Your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd encourage you to use paper and a pen to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity. It is a place of respect. It demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell. He has a tablet made available to him in the confines of his own jail cell, and he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said,
I
never,
momentarily.
no,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks,
I-
it's not
she's
your
saying-
time
no,
to speak.
No, I respectfully object. I never reported saying what day. I never said a day. And if she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little bit of
Just
leeway
you're
because we
saying
are outside the
that I've
presence
waived
of the
something.
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic? If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
All right, Mr. Brooks,
there no-
I've
is there
given
no verification?
Mr. Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to be
twice.
able to speak up,
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you provide
was not
information.
polite. That was abuse.
That's at least the
that was
third
abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because that's
So he's outright refusing to listen.
I would
He's
not sit
outright
here
talking over me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at
I'm
the
not.
point
I'm not gonna.
yet again
I'm not
where
gonna
I
sit.
will put you in the other courtroom because
And
you
I
are
don't
not
consent.
able.
I don't consent to being removed. I have not waived the right to be present, and I don't agree with that.
Mr. Brooks,
Does the
I
record
have
reflect?
provided
does
you
the-
on multiple occasions and it's should be in front of you,
No,
and if
I don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have been
it, and I
advised
haven't
on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant.
yourself,
I don't recognize the name
that all of the
this
rules
state
of courtesy and
put on
decorum
their
apply to
complaint. I don't
you.
recognize that name, Your Honor. That is
Supreme
not who I
Court
am.
Rule 62.02 details many of the requirements for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1 sub F of 62.02, that proper conduct and attire is expected within the courthouse, and where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself in a civil manner. You've been advised multiple times that this court will not tolerate disruptions, interruptions, that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior is repeated interruptions of this court, talking over this court, now talking over the prosecutor. I appreciate that you have not interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means. At this time, I would like to hear from the court administrator, especially as it relates to the protocol. Jail administrator. Did I say the court administrator?
Yes, that's all right.
That's okay. We're in court, and I would like to hear from the jail administrator. Thank you very much. And just to get some general information and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhaupt here, if she would come up to the witness stand.
Your Honor, if I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you. I have a list of a bunch of things I want to go over, and I'm going to...
So, Your Honor, respectfully, just so I'm clear, are we addressing the issue at hand now?
We are.
Or are we addressing something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment. So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear?
So they're calling his bluff, and I bet Brooks was not expecting that. I would guess that after listening to his phone calls from the night before, they had this whole thing planned out and ready to go. All they had to do was bring the jail administrator in and just wait for Brooks to paint himself into a little corner.
Would you please state your first and last names for the record?
Angela Wallenhaupt.
Would you spell your last name?
Wollenhaupt.
Thank you. If you could please advise us on the record again of your job title and responsibilities.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Could you provide information to the court on the general COVID protocol within the jail?
Judge, I would prefer to not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on, that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put all of your operations on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access to a conference room if he needed it, access to a telephone, and we would be able to, it's a safety security measure for him as well as our staff, and we can safely produce him for court.
When I hear the phrase being on a protocol, that to me could have more than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about what everybody's situation is different.
Right. And I'm specifically referring to your situation.
Well, the question was asked in how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right. I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No, I do not understand.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that
No,
information.
I don't understand.
So
I didn't consent to understanding or agreeing to that. No, I do not understand.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test, to which he refused.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests available in the facility to offer to an individual?
I have one available right now.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them. Can I ask a question, Your Honor?
Of me or of the witness?
Jail administration.
Go ahead, you can ask a question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why?
Sir, what's the question?
I asked the question, why would I not be given the correct test from the get-go instead of having to take two tests? If I've already taken one test.
You have to give her an opportunity to answer, and you got to ask one question at a time.
I just asked the question.
Can she answer it then? Do you want her to answer it? I presume you do since you asked the question, so you need to stop talking so that she can answer it, okay?
Well, limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said 2 tests. If it was, why would I need to take 2 tests for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
Right. So I'll sustain the objection. I'll give both parties an opportunity to ask questions of this witness since it's Mr. Brooks's request. I know do you have any other questions for Jail Administrator Wallenhaupt on this issue at this time?
I don't think I was clear, or I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take 2 tests for the same thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
Now I'm going to object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have another question? A different question?
Would it be any way to verify why I would need to take 2 tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhaupt.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I
I
say
understand
that-
what you're saying. Do you have any other questions for her, though?
Are you sure you're wrapping your head around what I'm saying, Your Honor?
Do you have any other questions for this witness?
To your knowledge, you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with a medical provider.
Thank you. Next question, if you have one.
So there are more than one type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing for medical conditions. That would be our medical contract.
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that he did submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her role in the Waukesha County Jail as the administrator and not in charge of medical. I will find she does not need to answer that question because it's outside her scope. And to further answer it might be speculative. So, do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that the second test would be a rapid test?
I will make a determination on your motion after all of the evidence and testimony on this issue is received.
Is that an
I
answer,
can't
Your Honor?
answer that question at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff. Is it because we just said it would be speculative?
You
So-
were looking at me when you said that,
Well,
so are you, and I'm not gonna answer that question. I'm not a witness in this.
The
I
reason
make
why I
the
was-
determination
reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying to
Jail
figure out
Administrator
how-
Wallenhaupt?
I thought testimony was supposed to be the prosecution and the defense's time to ask
Sir, do you
questions.
have another question? Otherwise, I'm gonna ask the state if they have any more for this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If you were offered a test,
Objection, relevance.
no, it's a question.
Hold on.
I'm
You're
getting
asking
somewhere.
a
I'm going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer. But you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
All right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay,
question,
so why
and it's
would
not
I do it?
relevant. So
Why would
sit
I do
down.
it then?
You're done asking questions because you've
So
now
is that a
asked.
judicial determination?
I haven't made a judicial determination yet.
You're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
certain
Brooks?
questions of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed to the next courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wallenhoff,
estoppel either.
although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes.
Jay, for
To
relevancy.
your knowledge, are those materials?
The objection is overruled.
I'm sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that.
he
I
still
object to
able?
that, Your Honor. I'm not allowed to
Her
keep.
answer stands. There's no question to which to object.
Object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
have-
turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asked the
Right,
question.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
rather,
Wallenhoff.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So an objection goes to whether there's lots of rules of evidence that apply. But if you're objecting to her answer, that's a different thing. You can argue the meaning of that later. Okay, the objection. But then you have to say objection before she answers. You objected after she answered.
She didn't answer the last
The
question.
objection is noted. It's overruled. Her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail, correct?
Respectfully object to that.
Overruled. She may answer.
Correct. He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled. You may answer.
Correct, ma'am.
And
So you're going to
the protocol-
overrule everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has the criminal statutes.
I don't see
It has the traffic code. It has the rules of evidence. Well, it's on your table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that available to you.
Anything to me.
All right, I'm directing the bailiffs to remove him to the other courtroom. I've provided ample opportunity for Mr. Brooks to abide by the simple rules of decorum and civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack
I don't
of
give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't.
I'll
give
make a
consent.
more full record when we
I
are
don't
open
give consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
She gone. So once again, Brooks is being removed to the other courtroom because he can't stop interrupting. And everyone knows what a genius strategy it is to constantly interrupt the judge and generally treat the courtroom like it's an open debate. I mean, Brooks is at least 5 steps ahead of everyone else. And if he can just keep this up, there's no way they could possibly convict him, right? Anyway, Darrell had the deputies take the garbage to the other courtroom. And of course, she is going to take the time to cite case law again. You know the one, Illinois versus Allen.
All right, before we continue, the record should reflect that, and at the moment, Mr. Brooks is muted, so I can appropriately make my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal, assuming he can maintain even the simplest of civility and not interrupt other individuals in a way that is disruptive and disrespectful. And I do want to initially confirm, I know I could hear him until I muted him. I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. Prior to the court ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. I have cited repeatedly from Illinois versus Allen, which is the Supreme Court case from 1970, which provides this court with the authority to remove Mr. Brooks from the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. This is the Supreme Court stating, "We believe trial judges confronted with disruptive Contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Mr. Brooks. In that case, they were talking about the defendant, Mr. Allen. And here are the 3 options, at least that the Supreme Court acknowledged. But I would note, as they just said in this prior quote, there are at least 3. 1, bind and gag, thereby keeping the defendant present. 2, cite the defendant for contempt. 3, take him out of the courtroom until he promises to conduct himself properly. This court has repeatedly utilized the neighboring courtroom because I believe that provides Mr. Brooks with an opportunity to meaningfully participate in these proceedings while this court maintains decorum, dignity, and respect. It is an elementary standard of proper conduct to not interrupt. Mr. Brooks repeatedly interrupts. I gave him 9 warnings before I removed him to the other courtroom. As the court did in Allen, this court decided that under the circumstances to remove Mr. Brooks from the courtroom and to continue the trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom, that this is the proper response to his conduct. As noted in the Allen decision, the court stated, "We find nothing unconstitutional about this procedure." This is now the 3rd day of the trial. We struggled at times through jury selection with multiple interruptions, what I would describe as disruptions. So it's with that history we came into court today. Mr. Brooks persists in his unruly conduct. I would note, just as the court in Allen did, it is not pleasant to hold or to find that Mr. Brooks be banished from this courtroom as part of his own trial to the neighboring courtroom. And this is what the Supreme Court went on to say, but our courts, palladiums of liberty as they are, cannot be treated disrespectfully with impunity, nor can the accused be permitted by his disruptive conduct indefinitely to avoid being tried on the charges brought against him. It would degrade our country and our judicial system to permit our courts to be bullied, insulted, and humiliated, and their orderly progress thwarted and obstructed by defendants brought before them charged with crimes. As guardians of the public welfare, our state and federal judicial systems strive to administer equal justice to the rich and the poor, the good and the bad, the native and foreign-born of every race, nationality, and religion. Went on to state, but if our courts are to remain what the founders intended, the citadels of justice, their proceedings cannot and must not be infected with the sort of scurrilous, abusive language and conduct demonstrated by not only Allen in that case, but by Mr. Brooks in this case. I've also cited repeatedly to SCR Chapter 62, which contains the standards of courtesy and decorum for the courts of Wisconsin. I've advised Mr. Brooks repeatedly. I've had, just as I am holding a copy of Chapter 62 on yellow paper laminated, I have it myself. I provided it to the state. I provided it to Mr. Brooks. And those standards govern what I do, what the attorneys do, what lawyers, clerks, court personnel, even witnesses, defendants, jurors, and others appearing in the court. 2 of those subdivisions specifically talk about the expectation that within the courthouse, that those involved in the proceedings refrain from creating disorder and disruption. Another subdivision of that section discusses the expectation that those within the courts conduct themselves in a manner which demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. Once again, it did not take Mr. Brooks very long to begin interrupting. It is 2:39 now as I go through this decision-making and put my findings on the record, but his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he say, I object. He provide a basis. I oftentimes give parties, give me one word. Is it hearsay? Is it, calls for speculation? Is it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection, and I expect him to honor the ruling that I have made. If he can't do any of that, he will remain muted, and the process will then be, we've given him a sign. He's holding it up right now, demonstrating for us he has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those, even if it's striking testimony later on. I do expect his objections to be based in law. I note, was provided with the copy of, it's a selected statutes, including the rules of evidence. All right, go ahead, Attorney Opper. For the record, the mute has been undone.
Thank you. So, Ms. Wollenhaupt, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold
about...
on a second. Mr. Brooks, the basis for your objection at this time?
That it's relevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or the tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next question.
Nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a cart available.
Sure. Mr. Brooks had told this court earlier that he started feeling not well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled. I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
Of course.
if he were to complain of illness to a correctional officer or a lieutenant, would they document that in any way?
They would give him a medical request form to fill out, which would go to the medical department where he could have contact to medical staff, or it could be documented in the jail management system.
To your knowledge, was that done by Mr. Brooks last weekend, the weekend of September 30th and October 1st?
Not to my knowledge.
Okay. And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Yes.
Was that provided to him?
Yes.
If he weren't on a protocol, would he still get those things? Or does it depends?
It would depend what type of a protocol.
Okay, thank you.
Those were all my questions. Thank you, Ms. Wollenhaupt.
All right, Mr. Brooks, do you have any follow-up questions for Ms. Wollenhaupt?
I do. You stated that it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations, and my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
So that would be the question then. Well, no, let me ask this. What specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation being a little bit unique, would any protocol that I am on currently prohibit me from being able to shower and or shave?
Do you speak moving forward?
As of right now.
You would be allowed to shower on the protocol you're currently on.
Will I be able to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled. She may answer.
Mr. Brooks, we would monitor behavior and other factors in that and make a determination. There's procedures operationally in the jail that you can request those items. And
So
you
that would be independent of the COVID protocols.
correct, ma'am.
So, to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right. I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail. We're a little far field. I gave you a little bit of leeway, but we had started this off about COVID protocols and your current situation. So from my perspective, the questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense and this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Well, respectfully, Your Honor, that was brought up by the prosecutor. It was brought up about the whole issue of being able, me requesting to be able to shower and shave. So that's why I brought it up in my question.
I understand, and I'm under my authority under 906.11. I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir. Thank you. Do you have any other questions for Ms. Wollenhut?
Yeah, a couple more.
Okay, go ahead.
Would you care to share with the court on record the types of protocols that I am currently on outside of the COVID protocol?
Objection, irrelevant. Goes to jail operations.
Sustained.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm going to have her not answer that as it goes to.
Well, that directly goes to that because as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the COVID protocol, the question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need? Because essentially, I'm only limited. I'm already limited.
Can I ask?
There's times.
I want to make sure I follow you, Mr. Brooks, so I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room? Is that a question you would want answered?
That would be fair, yeah.
All right, do you understand what he's trying to
So what
ask?
I'm understanding is, obviously, Mr. Brooks is allowed to keep legal material in his cell. He will remain in his current housing location. Access to the conference room, it will not change that, which is outside of his housing unit. And access to the phone could be granted upon request in the day room area.
All right.
So I do not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do. As far as he just referenced the telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that
Let's not talk about other inmates, but again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking...
Okay, let me ask it another way.
Okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
I think I was very clear with it.
Are you trying to ask her?
Are you aware, which I know you are, that the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I just said. No, not in a sense, because I think it's more accurate with the way that I asked it.
But your question assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case. So I'm going to limit your questioning in that way.
Well, can we at least make a clarification on the record that the reason why we're having this didn't have anything to do with limiting my preparation?
So
that wasn't the real issue.
I think it's related to the...
I just wanted that clear.
I understand.
That's all.
I understand what you're saying. I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me for this court to know how the COVID protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue, but nonetheless, I think it's appropriate for the court to consider those things. I heard the jail administrator indicate that the phone privileges would still be available upon request, and I guess to the extent that that's different, if at all, from the standard protocols that you're under, I would accept that as an offer of proof from you.
Well, I didn't agree to that, but the reason why I brought it up was because I've been on outside of the COVID protocol. The protocol that I've been on for a very, very long time. So my phone use is limited to certain hours of the day, which works out.
All right, Mr. Brooks, we're getting a little far field. I need to make a determination on your request, so I'll ask you one last time.
You haven't let me finish what I will.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking more about things you would provide. So if you have a question that's relevant, please ask it.
I didn't say anything I would provide. Where did I say that?
When you provide information through just a statement about things, that's not evidence, right? The witness on the stand is providing us testimony. Testimony is evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Well, everything you just said still speaks to not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered. Mr. Brooks, I need to make a ruling right now. Please stop. He's not answered my repeated question as to whether he has any additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhaupt is on the stand. I just have a few questions related to that, Your Honor.
I object to that. Relevancy, what does it have to do with what she's testifying to right now today? They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record. 258, you said?
Yes.
I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today. How these are two separate issues.
The court recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We have the jail administrator here. It's an important housekeeping issue as we go forward. And so I'm going to address it after I address the motion to adjourn that you filed. But since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Your statements noted of record. All right, go ahead, Attorney Opper.
Ms. Wollenhaupt, I don't believe you have the document in front of you, but thank you, Judge.
Record to reflect, I'm handing her a copy of what is in the record as document 258.
Thank you, Judge. I'm sorry.
That's okay, I'll print off another copy for myself.
Okay.
Can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect, he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to any.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed. So, and it's a document that was filed through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29, and it's directed to either clerk of court / Judge Darrell. So go ahead.
Thank you. Ms. Wollenhaupt, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that it's dated September 28, 2022, correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
And in this communication to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct. That's what he states.
Okay. Is that a truthful statement? Well,
It is.
let me ask a different. That's a bad question. I strike that question. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Again, that would be the banker boxes of written discovery in his own jail cell?
Correct. Anything that was in his jail cell, he would have access to.
Okay.
And he would also have access to the conference room and a tablet.
And the
in his cell.
Okay. And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do. You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to, so yes, what was in your cell.
Did you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So, am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was on the keep separate and that was going to hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So, is there a way to verify when the keep separate went into effect?
Objection relevance?
Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No, I did not. Ms. Wallenhoff just testified the last time that she gave testimony that she brought the discovery materials over on Thursday the 29th. She did say that in open court on
I
the
agree.
record.
Yep, she said that previously.
This inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue that keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
The keep separate protocol in itself, Your Honor, restricts the 2 people that have to keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. And the reason why I wrote, initially why I wrote it was because that stops me from being able to shower in the unit, because officers will have to then take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs.
Sir, I'm just going to stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure, at the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes that were brought over had not yet been delivered. I had already had maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right. So
That in itself was very, very voluminous in itself.
Sir, we had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that. So that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was made very clear to everyone that the jail administrator gave some specific directives as it relates to you and access to certain things.
I do recall that, Your Honor. And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order, I guess it would be called? I don't know what it would exactly, but the information that was to be passed down from Ms. Wallahouse to the officers.
Right, and I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system, it was documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So,
I would like to say something for the record, Your Honor, on that.
go ahead.
To speak to what you just said on that, it's possible that all officers were not aware of that. I even talked about this with an officer who worked just last night that wasn't even aware. And his answer was that he had been off for a few days, so to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tablet. So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
All right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Wallahouse, does a keep separate protocol restrict inmate movement in any way?
Objection, relevance.
Sustained, overly broad. Next question, or rephrase.
Does being on a keep separate protocol, or rather, should I refer to myself? If I am on a keep separate protocol, would that in effect limit me to only being in my cell and being able to only utilize what I would essentially have in my cell?
That's a compound question, so you have to break it down one at a time. So rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but the focus is how this impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday. And then the materials, even though they were turned over to the jail, it sounded like in the evening on the 28th, there was protocols in place to go through that. And then those were provided to you on the 29th. That is well established on the record. So I understand that. We've addressed that in part previously. So I know the state wants me to address this, and I think I know the reason why. But if there's any question you want to ask the jail administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well, I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was on a keep separate protocol at that time?
Asked and answered.
Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next question, please.
I don't recall her answering that specific question.
Next question, please.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms. Wallahop, that at that time, I was on a keep separate protocol, that it was already in the system that I was on that protocol?
What date are you referring to, sir?
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is the day that you brought over the discovery material, were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what date that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he has.
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand, so I'm going to ask you one last time, do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Objection, relevance.
Sustained. All right, then, I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
That was in the bounds. I just asked this.
The issue is limited to the impact of the keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks.
So
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
Would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opera, that would be permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
What does that mean? I do not understand.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means. That was a direct
One last time, sir. Do you have any other questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously outlined? Any follow-up from the state?
No.
All right, thank you. You may step down. All right, does the state have any other witness or evidence you want me to consider related to either of these issues, the motion to adjourn or the inmate communication form dated September 28 of 2022?
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since we obviously included that after we took up the other issue.
I'm still, I don't understand how any questions that I was asking are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to. Is it a way that we can verify the standards of the keep separate protocol?
Mr. Brooks? Mr. Brooks, please listen very carefully. There's a question I'm asking you is, do you have any other evidence, document? All right, then I'll. All right, I'm going to mute him once again. He is not answering very clear questions. I asked him if he had any information, evidence, testimony, documents he wanted to present. Instead, he asked me if I could verify, and that is not within my role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside over that, but it's up to the parties to present information, evidence, testimony to the court so that the court can address the requests and make decisions. I would refer Mr. Brooks back to the waiver of attorney form that was discussed last week. It is document number 244, scanned on the 28th day of September 2022, wherein Mr. Brooks was advised that the judge cannot be his attorney, cannot give him any legal advice. The district attorney cannot be his attorney, cannot give legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law, among other things, and that he is required to follow all legal rules and procedures that an attorney would have to follow in court. He was also advised, and this is just one part of that form, that it may be difficult for him to present evidence, may be difficult for him to do a good job as his own attorney. We discussed at length the advantages to having an attorney, the disadvantages to representing oneself. And what he is asking this court to do is to explain the law, and could also be described as a request for legal advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr. Brooks is holding up the objection. That we're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to talk about the evidence that I've heard here today by way of testimony, and to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing. I've stated pretty clear why it should be an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's clear to me that the wrong person was testifying. She said that she was not present for the said COVID test. So there's, to her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with, if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you. I don't feel good at all. My reason for raising this issue, like I said, was strictly a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with access to anything. It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have yet to even get the results back to say whether I'm positive or negative. I am fully vaccinated. I've never tested positive for COVID. And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid. Which is one of the reasons why I'm so concerned about the actual protocol, because once they informed me that I would have to be essentially quarantined and isolated, the first thing I was thinking about was how would I be able to use the phone and be able to tell my family what's going on? how would I be able to reach out to my kids and things like that to let them know, hey, I got a health issue going on in here that I'm worried about. That was my concern. And my intention was to at least be able to get the results back so that I know, okay, I'm good to go. Let's keep the ball rolling. That was my intention. Like I said, I just came to the knowledge this morning when they called me over to do the test. I had no idea that that was what they were going to do. Like I said, I didn't understand the protocol until it was explained to me. So I'm just coming into this knowledge as well. I'm still trying to wrap my head around it. With that, Your Honor, that's pretty much all I have to say. Is the intent of it was strictly that. And, you know, not one to, if I am positive, not wanting to infect anyone else or put anyone else in jeopardy. And also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy. That was my concern, and that's why I raised the issue, Your Honor.
Thank you, Mr. Brooks. I'm going to turn to the state then next. As a reminder, don't interrupt them. Thank you.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. I also would like the court just to acknowledge that document 258, and perhaps that's a moot issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail, he has always had access to his legal materials, the discovery in his cell, and the necessary tablet and computer so that he can prepare for his case. So I would ask you to deny the motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
If all parties will recall, one of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk. I don't see where there's any difference in my situation.
He doesn't understand the difference. Please allow me to make it clear for you, Mr. Brooks. There are a lot of differences between you and Detective Casey, but the most important one right now is the fact that Detective Casey didn't drive his car through a parade and run over a bunch of innocent people. Do you understand, little guy?
Also, very briefly, for the record, I was able to make a phone call, phone call attempts, because they were attempts, this morning after I came from getting the test, because I raised the issue, I said, since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity to try to notify my family of what's going on? That's why there were so many attempts, because I wasn't able to reach my mother, who pretty much has access to my kids. If I need to get some information to my children, she's the one that is in charge of all that. So I just wanted to state that for the record.
Thank you, Mr. Brooks. Well, the court has heard from Mr. Brooks. The court has heard from the jail administrator. The DA has provided some additional information as officer of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. We do not have the test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started experiencing these symptoms. Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments, or arguments for short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the court. He at times appeared animated. He appeared, again, to understand what the court's either questions that the court was posing to him or information the court was providing to him. He clearly was able to Mr. Brooks, please don't interrupt me or I will mute you. He was able to follow the questioning and answering process with the one witness who was here today. I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it was really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today, he is very able to assist in his own defense. He's able to present arguments, etc. I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet. That is an important consideration that has been one of the topics of guidance from the CDC, certainly one of the or part of the guidance we have received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing, the court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. He has full access even with this protocol. He has had access even to the phone. There's been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue. I'm also concerned about the fact that he would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately. And he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety concerns he has for his own safety can again, be met. The jail's able to get him here. The jail, of course, is responsible for his medical care. We can keep him 6 feet away from any other person. Obviously, if he's removed to the other courtroom, that provides a greater buffer as well. For all of those reasons, I'll deny the request to adjourn. As to the issue that was raised in the inmate communication, obviously this was a form that was sent by Mr. Brooks on Wednesday, September 28th of 2022. That was the day on which this court granted his request to represent himself. We know from the record, not only from today, but previously, that on September 28th of 2022, what he would have had in his cell would have been materials previously provided to him by his attorneys. His attorneys, through Attorney Perry, dropped off 3 bankers' boxes worth of materials and a flash drive to the jail later that date, and the jail followed whatever protocols they have with regard to those materials and reviewing them, and that those materials were provided to Mr. Brooks on September 29 of 2022. He's confirmed through the most recent request to adjourn that he wasn't even making that request based on any type of access limitation to materials or things of that nature. Although not a specific statement by him, this court would take that to mean he has been able to continue with his preparations. I'd also put on the record that there's no doubt that being in trial can be exhausting. We, of course, had 2 afternoons of hearings last week. Of course, he was provided with a lot of material. From my perspective, he clearly understood the perils of self-representation and the volumes of material that he would need to review perhaps a second time because he had some of them, or for the first time. Those were things that were clearly, he was clearly advised of before I granted that request. And then, of course, we had 2 very, very long days of jury selection yesterday and the day before. Given the way this jury selection progressed, we did not start with court until today at 1:30. Frankly, part of that was done not just to provide access to the media pool and the cameras and other things that needed to be installed, but honestly, to provide a little bit of a break for myself, and I would hope for the other parties as well. Of course, everyone continued on with their preparation, but I actually understood this request. I may not have referenced it previously, but that really factored into my decision to start later today as well, and to not bring the jurors in until tomorrow. So I am satisfied that Mr. Brooks has access to his materials that he needs to prepare for trial. As I indicated earlier, I have also provided to him the Wisconsin Criminal Code and selected traffic statutes, including the Wisconsin Rules of Evidence. It's from 2018. While there might be some slight modifications to some of the substantive statutes, this would give Mr. Brooks a very good reading as it relates to the rules of evidence and the statutes that relate to the charges he is facing. I'll provide a copy of that, a photocopy of the cover, so that it's docketed in the case as well. While this court is under no obligation to do that, since I was able to locate that, I am putting that on loan to Mr. Brooks. What he also needs to understand, though, that at this point it is for use in the courtroom. I would entertain a request that it go back with him to his room on a couple of conditions. One, it would be that he agrees to bring it to court each day. Two, that it be maintained in its current condition. And then three, that it's returned at the conclusion of the trial. So that will be for him to decide how he wants to do that. He has been raising the sign objection at all times during my oral decision. I would note the use of an objection is when the trial is in an evidentiary phase or a motion where we're talking and addressing the receipt of testimony and evidence. It's a mechanism under the law by which a party objects. They usually state either a 1 or 2 word basis. Sometimes it might be a short sentence or two. Sometimes the other party's given an opportunity to respond if it's self-evident to the court as to either what the objection is or the basis for a granting or denial. But the court rules on it, and then the parties move on. Those are the not only expected procedures for this case, it also comports with just the basic tenets of civility and respect, that you don't interrupt. Again, an objection is a legal basis to interrupt, but it's done in a way that's respectful. Simply holding up a sign that says objection is not does not comport with those expectations or procedures. All right, so I've addressed those two issues. I have a list. I'll tell the parties what's on my list, and then you can add to that as well. I do know the state filed a motion for reconsideration, so that's on my list as well. I wanted to touch base on the request for an interpreter. Again, the motion for reconsideration. I've already addressed the subpoenas. Madam Clerk, can you just confirm for me that they were signed by the clerk's office and then the 10 copies were provided to Mr. Brooks?
Correct, while he was sitting here.
While he was seated in the courtroom.
This morning at 11:18.
At 11:18 this morning, he was also provided with copies of subpoenas. Do you know how many copies were provided?
21 this morning.
21 this morning, an additional 10, I believe, this afternoon. So he has those available for his use. I've already addressed the statute book, so I can cross that off my list. And then, of course, preliminary jury instructions. Now, I know Mr. Brooks, I think, did not bring his with. I wanted to make a change to those before I printed off a copy for him. It's not a huge change. It's really just an addition. And it has to do with some of the language that I have been stating to the jurors if there have been disruptions. Not every time, but I do feel it's important to put some language in after jury instruction 70. But I'll get to that. We'll probably do those last. Attorney Offer, anything you would add to the list that I have?
Yes, Your Honor, I just wanted to understand some of the logistics as far as objections and cross-examination and exhibits. And I also have the state's witness list prepared and filed. I filed it at the start of this hearing. I'm sorry, did I say witness list? Exhibit list. 8 pages right now with 140 items. I was going to make that available. So I guess I have a question about that, and I don't know if you want to take that up right now or not.
I have one other, give me your whole list though too, and then I have one other thing I need to add as well.
And then criminal records for state's witnesses That was it for my list. Then the rest overlap with your list, Your Honor.
I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I will unmute him momentarily to ask him a question, and that question is whether there are any housekeeping issues on his list. All right, Mr. Brooks, are there any additional issues that you believe need to be addressed? Mr. Brooks, can you hear me? Mr. Brooks? Do you have any additional issues to what I've already set forth and the state's added to the list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but.
I was having a side conversation with the bailiff about something, so I didn't hear the last part of what you said.
It's my understanding that the bailiffs would not be having a conversation back with you or at you during court proceedings. So I'll have to confirm or deny that with them. Becky, if you could talk to the bailiff, please. All right, so it's my understanding you were asking the deputy how to pronounce a word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
What do you mean by that?
It was kind of a response.
Did he provide a response verbally?
I'd rather not say.
I'll have to get clarification from the bailiff later on. He's coming in here. Okay, thank you. Did you provide a response to Mr. Brooks?
I just told him I didn't understand the word he was asking me. He asked me to pronounce what the pronunciation of a word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'll ask you one last time. Do you have any topics that you believe should be on the list of housekeeping items to address today, other than the ones I've provided to you?
I did not hear the ones that you are referring to.
All right, listen to me now because I'm going to go through the list. Some of them we've already discussed, so I'm going to give you my whole list and then I'll say whether we need to address them or not. We have to address preliminary jury instructions, the state's request for an interpreter, the state's motion for reconsideration. I'll get to that momentarily. I've already addressed the subpoena request from you. I made a record of that. I already addressed the fact that I provided you with selected statutes. If you didn't hear, I'll state this part again. The book that I provided to you that was on your table when you got into court today, and that I believe is on the table, or at least was taken over when you were removed to that courtroom, is the Wisconsin Criminal Code and Selected Traffic Statutes, including the Rules of Evidence 2018. It's a State Bar of Wisconsin Pinnacle publication. It's probably about 2 inches thick or so. It has a reddish or maroon in color cover and binding. That's been provided as a courtesy to you. It's been provided to you to use in the courtroom. I would entertain a request from you if you want to take it back to your cell as you prepare on the following conditions. 1, you agree to bring it to court each day. 2, you maintain it in its condition presently. And 3, you return it at the conclusion of trial. I'm not asking you to make a request at this time. It will stay in the courtroom unless you at some point make a request. The other issues, hold on, sir, let me get through my list. The other issues are logistics regarding objections and cross-examination, the state's exhibit list, which was filed earlier, criminal records for state's witnesses, and then I have an added topic related to court TV exhibits and FCC rules. and just some things that may be impacted during the broadcasting of the proceedings because of the FCC rules, which I will claim I'm not an expert on, but I felt compelled to at least tell the parties. I'll start with that so I don't forget, and that is I have been advised that there are FCC rules that may require graphic images or videos to not be broadcast. And I know the state at one point had made a request, and we had talked a little bit about individuals who are victims appearing in a remote location and watching the live stream and seeing those exhibits. And originally, I had planned to utilize Zoom, and there's a share screen option. I'm not going to be utilizing the Zoom because of now the new mechanics for the live stream and the pool feed that Court TV has taken over and is providing to all of the other media that wants access to it. So I just wanted to make you aware of that.
Thank you, Judge. And I believe there was a workaround that was accomplished with the cooperation of Court TV and the county IT so that the victims will be able to view whatever is being shown in the courtroom, notwithstanding what's broadcast to the general public under FCC rules.
Excellent. I'm glad to hear that.
Yeah, and I would like to know for the record that the Court TV was very accommodating and very helpful in that regard, and we appreciate that.
And as a reminder, so you'll see there are some cameras that have been installed in this courtroom and some microphones. Like I have an additional microphone next to me. There's a camera down in front of the court reporter. There's a camera in the back. And there's a camera over to my left in the clerk station work area. I've also indicated, because now we may have to use the adjoining courtroom, they're in the process of getting some equipment so that there's a camera in there as well. I know that needs to be worked through with the county facilities because of the cabling and all of that. So I just wanted the parties to be aware. I have approved of all of that. That brings me to a related topic, and that's the use of the courtroom microphones are still an audio backup, but we have really good microphones in this courtroom. The state noted it yesterday, or maybe it was the day before. At one point, Mr. Brooks appeared to be muting the microphone in front of him. But because there's microphones elsewhere, we were still able to see the audio. I'd advise the state of the same thing. You have microphones behind you through the court system that just because you mute the one in front of you, you may still be picked up. And that just whispering still comes through on the microphones, whether they're the courts or otherwise. So,
Can I ask a question about that?
sure.
During recesses, is it possible to mute all microphones so we can confer?
Absolutely.
Okay.
Remind me,
Sure.
right? We need the clerk to do that. But I think if we all cooperate together, we will get that done.
Thank you.
All right. Any questions about the broadcast, Mr. Brooks?
I didn't really understand the whole gist of it. So, I'll go with the part that I don't think that if you are not in the courtroom that you should be privileged to see anything. I think the word you used was graphic.
It's hard to believe just how dumb this guy is. They just finished explaining that no graphic materials were going to be broadcast.
I am not responsible for Court TV's compliance with FCC regulations, but it's my understanding that they will meticulously follow whatever the regulations are. But what's in the courtroom is clearly going to be what's in the courtroom, and anyone in the courtroom will be able to see fully based upon the monitors, including the jury, including the court, and including you, whether you're in this courtroom or the next courtroom.
Yeah, that would be the preference. If you're not in court, you shouldn't be able to see everything in court.
All right, moving on to the next topic then. There's a state's request for an interpreter. I wanted to address that because the form that you used, and thank you so much for doing that, requires that I sign an order. But it's my understanding that that request may be modified.
Yes, Your Honor, as to the timing, certainly it will be modified, because I think I indicated October 6th or 7th. I no longer anticipate that being necessary. It would likely be one day next week. If you give me just a second here, I can maybe give you a better idea. I'm wondering if the court, I hate for the court to pay for an interpreter that we don't use.
Oh, I don't think you should even worry about that, because now that you've mentioned it, Brooks is going to make sure the court has to pay for an interpreter.
So I don't know how much notice you need to give to the interpreter, or how far in advance you have to reserve them before you have to pay them no matter what. I don't know if they have rules like that or not.
They do.
Okay.
It depends.
Okay.
So thankfully, we have one local interpreter who is incredibly reasonable, and I know is kind of on notice, but it really depends on his schedule. And what we may have to do as the courts, because you are correct, it's the court's responsibility to do this, to pay for it. I will not make arrangements just yet unless, just based on the request that was made, because you said it's no longer a date that you would target for that interpreter. I'll decline the proposed order. And then just if you want to resubmit, of course, we have someone in the clerk's office who is parties work with regularity to obtain interpreters. And so the state can simply continue to work directly with that person to facilitate and hopefully keep the costs down. We'll deal with whatever the fallout financially. Typically, we need 2 business days to cancel them. So if you can make arrangements, for example, say next Thursday or Friday for those witnesses to appear, and then you decide you don't need those witnesses, and we should be able to cancel them by Tuesday or Wednesday, depending on the day that we've selected.
Sure, I understand. That's very helpful, and we will definitely be diligent to keep the court informed. I understand. I agree. It's appropriate for the court to deny my request today, and I will renew it as needed.
You know, as I think about that, I think what I'll do is I'll approve it, but I should be able to add some language about this date may be modified through direct communication between the DA and the person in the clerk's office responsible. I don't need you to file again and again if it's really the same request. It's just the date is changing, and you're doing that in order to, frankly, save money for the county.
Yes, that's exactly our intention, Your Honor. Thank you.
Let's go to the motion next. At least preliminarily, did you serve that motion on Mr. Brooks?
No, Judge, I don't think I did, to be fair. I had it in my office, and I was going to ask Detective Regland to take it over there, but I don't believe I ever actually did that.
All right, I will ask that you have that served upon him right now, and that will obviously impact the timing of when I can address it, but we'll save that near the end. But I'd ask that you, Detective Regland, go do that right now, and I will just pause momentarily so that can be done. All right, we are back on the record. Then appearances are as they were before. Mr. Brooks, I'd like to invite you back into the courtroom if you so choose. You have been respectfully participating from the other courtroom. Of course, if you do come back in, you, of course, would be expected to abide by the rules of decorum and courtesy. Would you like to come back to this courtroom, sir?
I never stated that I wanted to be removed in the first place.
My question to you, sir, is would you like to come back over to this courtroom?
I respectfully never consented to being removed.
I will ask one last time before I consider his answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom.
Not respond. I responded. You just wouldn't accept it.
The record speaks for itself, sir.
Which, Your Honor, I'm very tired, so.
Mr. Brooks, we're gonna keep going. So please don't interrupt so that we can do this as quickly as possible so you can go back to your cell.
I was just merely trying to make the record, which you have denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
Mr. Brooks, I'm not going to respond to that simply because if you want to file an appeal, then you should take the necessary steps to do that. All of my decisions are on the record. You can request a transcript if you want to have a written copy of what was said in court. I can't provide legal advice on how to pursue an appeal, but I would not grant an appeal. That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks,
Can you verify that?
Mr. Brooks, I'm going to mute you, okay? Mr. Brooks, you've now earned the mute button once again. Despite you saying that you're tired, you had no difficulty making objections, objecting, and once again asking for an appeal. So I need to get going on this hearing, and that's what we're going to do. I would like the state to confirm on the record whether you've had an opportunity to have the motion served on Mr. Brooks.
Yes, Detective Reglan personally served it on him about 10 or 12 minutes ago, Your Honor. Also at the same time served him with a copy of the state's exhibit list, which I believe we will be addressing at later this hearing.
Right. As to the motion, I would like to give him an opportunity to review that. It is a motion for reconsideration. And so I'm not going to address that today. I'll have to address that tomorrow morning.
Understood.
Thank you. Why don't we start with one of the latter things that you indicated, and that's the criminal records for state's witnesses. How many witnesses would this issue relate to?
One.
All right. And would you have a copy of that record, or I don't know how do you provide that to the defendant? How would you like to provide that to him, at least the information?
Well, I'm prepared to make an oral statement today, and then I have a CCAP entry that I would choose to provide to Mr. Brooks to verify what I'm saying.
Okay, go ahead.
Your Honor, this relates to one of the state's potential witnesses who's identified as the father of victims KKK and victim LLL, who is expected to testify. He has one prior misdemeanor conviction from 2005 for a crime of entry into a locked building. I would note that it's the request of the state that although he does have this one prior on his record, the court make a finding that it's not relevant or probative, in that he was 21 years of age at the time it occurred. It occurred 17 years ago, and there's been no further events or criminal wrongdoing in the meantime. I don't think it is probative of his truthfulness. It was not a crime of truthfulness, and we would ask that, although that record does exist, that he cannot be asked about it when he testifies. He is the only citizen witness that has any appropriate criminal record to discuss.
Again, you said it was 17 years ago, but how old was this individual at the time?
21 years of age.
So I'm going to take this request under advisement. I'm going to advise Mr. Brooks that the relevant statute is 906.09, impeachment by evidence of conviction of crime or adjudication of delinquency. I have provided him with that selected statutes book, so he can review this if he so chooses, and then at the appropriate time, I can readdress this.
I'll remind you before this person testifies, Your Honor, if not before, but.
Right, I think that would be the best way to do this. Just maybe give us, if you can, a day or two notice so that he can, meaning Mr. Brooks, can look at the statute again if he so chooses. So what I'm telling you, Mr. Brooks, is that I'm not going to address this request today. The state's put this information on the record. I'll require them to provide the CCAP information that they have regarding this individual. That individual would be on the witness list. Is this person indicated in any way on the witness list as the father of so-and-so, or would it be?
No, but when he gets the CCAP entry, he'll see the name.
That's true.
Yes.
All right, thank you. So that's how you'll get that information, and then I'll address whether that impeachment evidence is relevant and probative at a later point in time, but at least you're put on notice of the request. And again, I'm not going to address the motion for reconsideration because you were just served with a copy of that. I will take that up tomorrow morning.
If the defendant should testify, we would want to discuss his prior convictions as well. We don't have to do that right now, but I at least wanted to discuss about the state's witnesses, Your Honor.
Sure. If you wanted to provide a little bit of information, again, he's been given the statute. He could review that. Do you have a total number of convictions for Mr. Brooks, and the number that you would ask be the number he answered the question to? Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor. We believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from Milwaukee County, but also 1 conviction from Wood County and 1 conviction from Manitowoc County. And we would certainly provide Mr. Brooks with either a criminal history or CCAP printouts, whichever he would like, to support these convictions, except for the Nevada. That would be on his criminal history. We can provide him a CIVR.
All right, so Mr. Brooks, I'm not going to address this today. The state's putting you on notice that if you elect to testify in this case, they will be seeking a ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times? And that number is really up to judicial determination under the statute and relevant case law. Again, not going to take it up here today, but you're put on notice, and the state will provide some information to you to substantiate the convictions. I'm going to unmute. Do you have any question about the use of criminal records for witnesses and impeachment, at least the mechanism for which to address those as I've outlined here today?
I think once I'm able to review things, I will have a better understanding. At this point, I don't.
That's okay. So, understood.
I do want to just say one thing, and not to that. I just wanted to say one thing on the record, that I did inform the bailiffs that I did not wish to accept the paperwork that was brought off by the detective. I don't know his name, so I don't want to be disrespectful.
The information I have is Detective Ragland did personally serve you with that. He'll file the appropriate service if need be. Whether you take that paperwork with you or not back to your cell is your decision, sir.
Well, I just wanted to put that on record that I'm not accepting the paperwork.
Your objection to the paperwork is noted. All right, that might be a good point to talk about objections during trial. That's a good segue. We talked a little bit about that during the testimony today of the jail administrator. Sir, once again, I direct you to the rules of evidence. I actually have a large binder that I utilize as judge on the rules of evidence. There are many rules as it relates to the admissibility of evidence, foundation, authenticity, etc., and other things. Typically during a trial, because I'd like to minimize the information that's before a jury, is I ask parties to, if they have an objection, objections, generally speaking, go to testimony or evidence. So for example, if a question is asked that you think calls for inadmissible evidence, you'll let the attorney asking the question fully ask it. You say objection. If it's a relevance objection, I'd like you to say relevance. If it's a hearsay objection, say hearsay. I don't mind a sentence or two, but what I try to avoid is a full legal discussion in front of the jury. If I feel it's appropriate once the objection is made, I'll either sustain it, overrule it, or I might say to the other party, so if you're making the objection, I would say to the state, any response? They might say something like, let's say you make a hearsay objection. Your Honor, it's not hearsay, it's not being offered for the truth of the matter asserted. That triggers to me, I understand what I need to decide at that moment, and I might say sustained, or I might say overruled. The witness may answer. The jury's instructed that the information or the testimony being provided is not being offered for the truth of the matter asserted, something like that. However, if it's a more complicated issue, sometimes the state will tell me and ask me, Judge, may we have a sidebar? We don't really have sidebars in a situation like this where you're in custody, but using that phrase is still acceptable because then it prompts me to have the jury excused so then I can have a more full discussion with the parties, hear their legal arguments and reasoning. Sometimes it requires an offer of proof. And so what I'm advising you, sir, is because the state bears the burden of proof, they're going to go first. They're going to present witnesses. If during testimony you believe certain testimony is not admissible under the rules of evidence, you can certainly object. I'll rule on that objection. I ask that you wait till I rule on it. But once I've made my ruling, it's either going to be the witness will be allowed to testify or the witness will not. So whether you're the one making the objection or the state's making the objection for something your witness might say, I expect that you will honor the ruling and then either move on to the next question as the case may be, or, for example, if I've overruled an objection of yours, to allow the witness to answer. And the record will reflect that an objection was made, and that will be there for appellate purposes later on. If we get to a point in time in the proceedings where you have been removed and you are appearing from the other room and you are not able to follow this procedure, I will warn you now that I may mute and probably will mute in those circumstances. You have been given the objection sign. You can raise it. I will unmute and say the basis for the objection, sir. You'll state it. I'll mute you again. I'll rule on it, and then we'll go on. If at any time, though, that even that secondary process is very disruptive, then I will require you to write down all of your objections. And then let me rephrase that. I'll require you to write them down. If that means I have to wait for the sheet of paper to come over, I will. But at some point, sir, I'm going to keep this trial and the testimony going. I would direct your attention to 906.11. So 906.11, which concerns the order and mode of interrogation. The judge maintains the ultimate control over that. And if you intend, or if at any point in time you just simply object to every question, that is not going to be acceptable. Because also under 906.11, you can't harass a witness that way. So I want to make that clear. Attorney Opper, is that a procedure? Does that answer your questions about the procedures for objecting?
Yes, that answers our question as to objections. I did have another question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed the case law, and one of the possibilities is that he forfeits his right to cross-examine. If he's not in this courtroom, it can be challenging to facilitate cross-exam. And if he's able to abide by the rules of decorum and civility, and whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court has been more than patient. We would just ask the court for continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated on the 2 occasions so far that we've had testimony, he's quite efficient at asking questions, and so if he is calm and cooperating and not rude and disrespectful, we believe he should be given the opportunity after every witness to cross-examine. Even if he's in the other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
Okay, thank you.
Just so I understand, if I don't, how can I forfeit my right to actively and effectively participate in a trial if I have to constantly be put in a separate location? How will I be able to see everything that is going on in the courtroom? How will I be able to effectively put on a proper defense?
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
Just so I understand, the Supreme Court, the federal court?
That is the Supreme Court of the United States of America.
Is that federal?
That is the Supreme Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that is the Supreme.
So
Sir, I've answered the question.
you have, but I still don't understand. That's why I'm asking the question. I'm not disputing it.
Sir, I'm not going to explain the law to you. I cannot do that.
I'm not asking you to. I'm asking, is that a federal court?
All right, I'm going to move on to the next topic. Related to objections would also be to the admission of evidence. Of course, my standard practice when a party offers an exhibit is to say any objection. And so If there is an objection, of course, there needs to be a legal basis. And then once I rule on that objection, then I expect that decision to be respected and honored, and the testimony and presentation of evidence continue forward.
So, Your Honor, I still don't understand, how am I expected to do everything in a legal basis, in a legal manner and everything, when I keep informing you, Your Honor, on record, in open court, that I did not understand, that I still have yet to understand the true nature and cause of the charges against me, which I don't understand. There's so many things that I do not understand that I keep explaining to you, Your Honor, that
Mr. Brooks, I'm going to refer you back to document number 244, which is the waiver of right to attorney form that you willingly, knowingly, intelligently, from my perspective, understandingly filled out. Let me make my ruling, sir. Do not interrupt, or you will be muted. All right? So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form, the advantages of having an attorney represent you, the disadvantages of representing yourself. I discussed with you and advised you regarding all of the charges that you face, the penalties that you face, the exposure that you face. I advised you regarding what an attorney would do. I further advised you about the disadvantages of representing yourself. I asked you such questions about whether anyone, forced you or coerced you to waive your right to an attorney. I asked you if anyone had made any promises to you to waive your right to an attorney. I made a finding, sir, that you freely, voluntarily, intelligently made a deliberate decision to waive your right to counsel and to represent yourself. I refer you to that document, sir, because once again, I cannot give you legal advice. I cannot explain court procedures or the law. And you represent yourself at your own peril. I honored your request to represent yourself, and it's a bit disingenuous to now say you don't understand what you did. So we're going to keep going. I need to go through some other topics. You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything. I was just letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal. Again, I do not understand, and Your Honor, I think it's very unfair for you to say that you're finding that I understand. How can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I don't understand. And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I did not
Mr. Brooks,
understand.
I'm going to mute you because we're off topic. We've gone over this time and time again. I understand the objection that you're raising. You once again are claiming that you do not understand. I make findings in this courtroom based upon the available information, the law, and my decision is all in the record for which you can appeal at a later point in time. But we are going to continue whether you claim to not understand. All right, so I need to add one instruction to the preliminary jury instructions. Have we provided Mr. Brooks with his another copy yet?
Not another copy, just the one from last night.
So the one from last night, my understanding is he left in his cell. So you can print off what we have thus far for him, Madam Clerk, and I'm going to just make a modification and print off a separate instruction that I have crafted regarding decorum and courtesy in the courtroom. All right, so he was provided with the packet of preliminary jury instructions. So let me I just need to add a line in here. I'll print this here for the state, and I'll print it in the other courtroom. There's a printer over there as soon as I do that. All right, I'm going to unmute Mr. Brooks for now. I was not looking at the monitor because I was sending the email to my clerk with that document, but I just like to get confirmation at least it was put in front of him on the table. Whether he accepts it or not, I understand, but Mr. Brooks, was that piece of paper placed in front of you?
I don't accept or consent to any paperwork.
Judge, I did see on the monitor that we have set some paperwork on the table in front of Mr. Brooks, and he took it off the table and set it on the floor next to him, it appeared.
All right, thank you for making that.
Accept or consent to that. I will
Mr.
not
Brooks.
accept any more paperwork.
All right, Mr. Brooks, you made clear you're not going to accept paperwork, but we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties. So what you do with them is up to you. So your objection is noted.
You may be aware that certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions. Are you willing to participate in this process right now?
No, I am not. And I don't give consent without me being present in the courtroom, like I said before I was brought over here.
Would you like to come back over?
So why would you ask me now? Why would you ask me now?
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior. If you can agree to abide by the rules of decorum and courtesy,
I'm not going to
then
agree to
I will
anything.
bring you back over here at any point in time.
I'm
Did
not
you
gonna
hear me
agree to
advise
anything.
you of that, sir?
No, I did not.
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time. If you come back, the court expects you to follow the rules of decorum and courtesy that you've previously been advised about.
So this is how it's going to be the whole trial every time I seek to understand
Mr. Brooks,
something
I'm
and ask a
offering you the
question.
opportunity to come back to this courtroom to participate here.
I don't want to go over there and then essentially have to come back right over here because when I ask something that I don't understand, it's being looked at as me intentionally trying to disrupt the court.
Mr. Brooks, I'm asking you a question. Please answer.
I'll ask you a question as well, Your Honor.
Would you like to
I'll
come
ask
back
you a
to the
question as well.
main courtroom right now? Yes or no?
I've asked you a question too, Your Honor. I've asked.
All right, I'm going to mute him. I'm going to make a finding that his decision to not answer the court with a yes or no is non-responsive. I repeatedly asked him if he would like to come back to this courtroom. He did not answer yes. Instead, he wants to debate with me about his understanding or lack thereof, and rather than discuss the topics at hand. I find that behavior to be rude, to be disrespectful. I find it to interfere with the orderly administration of justice. I want to continue with the preliminary jury instructions. Of course, it is always my preference to have Mr. Brooks in this courtroom, but as he has been advised repeatedly, in order for him to maintain his appearance in this courtroom, he needs to abide by even the most simplest of rules, and that is to not interrupt. I will not tolerate disruptive conduct that, from my perspective, is simply an attempt to avoid being tried on the charges brought before this court. All right, so I have a packet of jury instructions, and if I didn't state it, obviously the record should reflect I have muted Mr. Brooks, and he'll remain that way until he sends me a note indicating he'd like to be unmuted and that he will comply with the rules of civility and decorum. All right, so I've provided the parties with a packet of instructions. There are 68 pages. Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions? I will, Your Honor. All right, do you acknowledge receipt of those? Yes. All right, I will put on the record that the 68 pages were also provided to Mr. Brooks earlier today, I believe, at the start of the hearing. And then he was also provided with the single page proposed instruction regarding decorum and civility that the court has drafted. Has the state seen that as well?
We have.
My thought on the instruction that I provided to the parties, there is instruction 70. Mr. Brooks is raising his objection sign. If he has an objection, he needs to write that out and provide that to the bailiff so that I can then take it up. All right, so as the parties can see on the monitor, 70 is the instruction that is entitled in the drafts that are provided by the standard or pattern jury instructions, preliminary instruction, defendant, proceeding, pro se. Now, I would note, none of these headings are read during the advisement to the jurors. It's really so we can keep an orderly list of the instructions. So my practice is to simply read, starting with the substantive. So that is the pattern instruction. It's been modified to make sure it says himself versus herself, and the name of, actually it just says defendant, there is no name. And my suggestion and what I intend to do is to, right after where it says in any manner, is to start a new paragraph. So just underneath that, whether it has a heading or not, I don't think is relevant at this point in time, but to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance, are expected to conduct themselves appropriately and avoid creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. I would not read the SCR unless there's a request to do so. That is there just for reference. That's where I pulled that from. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that on the record. I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it. Inserting that, I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. If I read this at all at other points in time, I will use his name that I have listed on this proposed.
What is your name?
Brooks.
Darrell.
All right, Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Yeah, first of all, I'd like to state for the record that I'm probably not pro se. And what you just said about keeping it consistent,
then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location? If it's going to be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object, consent, agree, or otherwise?
No, I don't consent. I do not.
All right, your lack of, sorry, go
I
ahead.
just stated the reasons why.
Is that to the whole?
So yourself, you just said so yourself, they need to be consistent. So why does anything need to be changed at this point?
As to the entire packet that was provided to you, noting I've made this change, I will,
didn't
hold
accept
on,
anything
hold
that
on,
was-
hold on. I will advise you that as to the added paragraph, I will make it consistent with the verbiage and the pattern instructions and refer to him as the defendant. However, if I have to read this instruction at other points in time, I will be reading it with the verbiage of Mr. Brooks. I do that, frankly, out of respect for him. But the pattern jury instructions are constructed in such a way that I'm going to follow that pattern when reading instructions, with the exception that I've just noted, and that is if I am in the position where I feel it important to advise the jury, whether it's just simply that he's in another location or another courtroom, this must not influence your verdict in any way, or if I feel it important to read the entire thing. I'll take out the reference to SCR 62.02 sub 1 sub F and H. That was really just so the parties understood where I obtained that language from.
So what's being changed, or is it? I don't understand.
I changed where it said Mr. Brooks to the defendant. And that, I think, was in two.
Is it in the court of citizens ensuring that part?
Yes, so right there. We're in the process of changing it, sir. My clerk is typing as we go along.
Thank you. And I also want to make
Small d.
State this on the record. You just referenced wanting to protect my rights, correct?
You have the language in front of you, sir.
Well, you just said on record that you want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish. So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution. I should be able to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
I'm not gonna consent to any questioning about that. I think it was very clear on what I was asking, because I'm referring to you saying that you would like to preserve my rights. And part of my rights being preserved is to be able to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
So, as I understand what you're saying, sir, I think what you're asking this court is to add an instruction, because the jurors get informed. Hold on, let me finish. The jurors are informed of the law through jury instructions. These are the pattern jury instructions with the exception of what I've just added to number 70, which I feel is appropriate in this case. If there's something additional, then tell me what it is, and do you have a draft to provide to the court for consideration?
Well, how about this, since it's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that be sufficient for Your Honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
For the record, also, may I state, and it's going back to the language that says pro se. Can that be changed to pro per?
That's not read to the jury. It's just part of the labeling, but it is my pattern, but it is the pattern jury instruction. That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions. So my question to you is, oops, you can take that up.
I did have one suggestion.
Okay.
On the second.
Hold on, Mr. Brooks, what I want to tell you is, I'm going to finalize these. The state has a suggestion for verbiage within an instruction that's already in there that I'm going to address. I'm then going to ask you whether you have any other edits or requests as it relates to them, and then ultimately ask you whether you approve of these or not. I just want you to be advised of that. So go ahead, Attorney Basie.
Thank you. On the additional language that the court is adding to jury instruction 70, I would just state on that second sentence, my job includes making sure the defendant's rights are protected. So I think that should be the.
Right there.
Yep. Or I could just read, sure, the defendant's rights, whatever.
Since nobody's saying anything, part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately states.
That right preserved?
I do not believe that statement accurately reflects the law. All right, so we'll make Mr. Brooks, I'm moving on.
Can you show me by?
Mr. Brooks, I'm going to mute you. I'm not required to show you verification of law. Again, I direct you to the waiver of right to attorney form, a copy of which has previously been provided to you about what this court can and cannot do. That's a very good summary. If you have any other questions about what the court can and cannot do, I also direct your attention to the Supreme Court rules. My understanding is you have access to legal materials, and there are a number of rules that apply. The Code of Judicial Conduct is SCR Chapter 60. All right, we've made that change. With that change, does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm going to ask you that question. Actually, two, do you have any, and you're raising the objection. Hold on. You're raising the objection, signed. It's noted for the record.
I'm going to continue doing it. That's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me finish the question, sir. You're interrupting. All right, I'm going to have to mute him again so that I can get my question out. Mr. Brooks, my question to you Do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with? And the added instruction that you were able to see on the screen. Go ahead, you are unmuted.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I will be able to draft something up and get it to you. So why can't I address anything in that draft?
Sir, I am addressing what we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yeah, you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties.
Sir, I have provided an answer to that. All right, I'm going to object. I'm going to not object. I'm going to mute him again. I have told you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding. It's a non-response type of answer. Because I've advised him as to what I intend to do, I am going to approve the jury instruction packet that has been provided to the parties and modified on the record.
Your Honor, I do have one other change I just noticed.
Go ahead.
And it's with regards to the bail jumping jury instruction. And I know we had talked about this verbiage before about the theory of that charge is that the defendant committed a crime. It was our belief that they did not have to be unanimous on the crime that was committed. As I look at the jury instruction and it's talking about the third element, it says the state must prove by evidence, and I'm on page, 66 of 69. So the last paragraph before deciding about intent and knowledge, it indicates the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. The crimes, and then it lists those same crimes have been defined for you and should apply the same definitions here. I would just indicate I believe it should read hit and run resulting in death or battery. I believe that they do not need to be unanimous on the crime that they select, but they do have to be unanimous that he committed a crime.
Any case law or other support for that position?
No, Your Honor, I know that the court had addressed the hit and run, that they don't have to agree on which ones they violated, and that would be the analogy I would make. I know we had talked about that previously. What we could have done, it's to Mr. Brooks's benefits, that we did it this way because it's only 2 counts of bail jumping versus doing 1 count of bail jumping for each crime that he is alleged to have committed. We put them together, I guess, to the benefits, and he may not see it that way, but to his benefits.
Mr. Brooks, the state is specifically asking that I change the word and to or under the third element of bail jumping based upon their theory of this case and the bail jumpings and their belief that the jurors do not need to be unanimous as it relates to which crime was committed. And they're asking that I insert the word or as indicated. Do you have any position as to that?
Yes, I do. And I'm gonna base my position off of what you just said, that there is no case law to support why it should be changed. I believe that it should be whatever it is right now, that the word or whatever should not be admitted. It should be how it is right now, as apparently it was intended to be that way all the way up until this point, so why change it now? Let's just leave it alone and leave it where it is.
Well, actually, sir, the pattern jury instruction was modified because of the charges in this case based upon the state's proposed jury instructions that were previously filed. The pattern jury instruction basically deals with a single criminal law violation. That's not the theory of the case for the state here in this case as it relates to the bail jumping counts. So I just want to be made clear that it's not a change that they're asking to the pattern instruction in terms of what would have been there previously, because it already was modified based upon their theory in this case. To say it another way, the pattern jury instruction didn't contemplate, and they're just that, they're pattern jury instructions. Oftentimes the courts have to modify based upon the particular nature of a case. So my question to the state, and then will be to Mr. Brooks, is if I adopt the request from the state, do I need to put in a similar statement like what is in the hit and run about you don't need to be unanimous as to which crime he committed, but you need to be unanimous that he committed a crime?
I think that would be helpful to them. I think the paragraph before the one I just recited says the defendant is charged with violating a condition of bond that required that he not commit any crime. So I think that verbiage would be consistent with that first sentence.
Any position on that, Mr. Brooks? Or the, sorry, go ahead. Any position on that?
Yeah, I don't agree with why should it matter about a unanimous or not being unanimous. If that was always the case from the beginning, then it should have been changed at the beginning, not at this point where everything is so close to being decided. I don't understand why it needs to be changed in any way, why it needs to be altered in any way. I think if it was going to be that they had to be unanimous, then let it be unanimous. Let it be unanimous for everything.
All right, I agree with the state's position. I think that's the most appropriate under the law, given the violation of bail jumping. It can be a variety of different ways, but in this particular case, the state's relying upon that statutory subsection for violating any crime. So in element number 3, it needs to say the state must prove by evidence the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree reckless endangering safety, use of a dangerous weapon, hit and run resulting in death or battery. And so that I actually took out, where it says crimes, I changed that, I took out the S as well. I think that you would need to do that, or I would need to do that in order to be consistent with the or. So I'll make that change, and then
I'll make the suggestion that at least at the minimum it would say alleged crime, as I have not been convicted of anything.
I understand what you're saying, but these are the jury instructions that tell the jury what the elements of the offense are. It's very clear when you look at the jury instructions in their totality that these are the elements, that the state bears the burden of proof. There's other parts of these that talk about an information, that these are, that can't be used against you. I believe your concern is adequately addressed when you read the jury instructions as a whole.
May I ask Your Honor if there's anything that I can look up myself that would help me better understand this?
How many times does she have to tell this guy that she can't give him legal advice?
I can't answer that for you, sir. I can't explain the law to you. I know at times I've provided you with resources. I mean, what I have available, but I have no idea if you would have access to, because it's through a publication, I believe through the state bar, are the jury instructions. I'm not even sure if what I have To be honest, I know I get them through the Director of State Courts office. I have them available electronically, and the Jury Instruction Committee, which is, let me take that back. It's through the law school because of the Jury Instruction Committee, and it's a publication. I'll be honest, I don't even know how the public gets access to them because of how I get my access. It's just something that the Director of State Courts office provides to me through my judicial dashboard. And so, but what I wanted to say is those jury instructions come with comments. There's also special materials. I don't know how you access those outside of the way I do. It's been over 10 and a half years since I've practiced law, and the whole electronic access to these types of things have changed. So I'm just not able to answer that, sir. The packet that I'm giving you has all of the numbers on them, so that should help you in your research of them.
So I think where my the most glaring part to me of my misunderstanding is the unanimous ununanimous thing. I think that's what I'm really attempting to wrap my head around at this point.
Right. I'm trying to find the language in the hit and run about the duty that I would point you to.
Is that acceptable to you, Your Honor? That's one.
Your Honor. 61 of 69 under number 3.
Oh, right, I found it. So I'm just going to point you to under the jury instruction for duty upon striking a person, which is instruction 2670. Under element 3, there's a portion of that that says, the state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the two duties, but you are not required to agree as to which duty was violated. The proposed language that I would have is that the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. And I would put that, we're talking about the bail jumping jury instruction. It's also element 3. Right after where we says all of these crimes have been defined for you and you should apply the definitions here, I think it would make sense at that point to say the language I just proffered, which is the state is required to satisfy you beyond a reasonable. Actually, let me take that back. I'm looking further up where we're closer to the number 3. So it's my page 65. I don't know if it's 65 or 66 or 64 in yours, but where it starts with the defendant is charged with violating a condition of bond that required that he not commit any crime. And then it has a paragraph, and then there's another paragraph that starts, the state must prove by evidence would satisfy you beyond a reasonable doubt. It's before I say the crimes of have been defined, that's where I think it should be inserted. And so, Madam Clerk, where we made the change where it says or battery,
Yes.
then we'll include the following language. The state,
Before or after the period?
after, it'll be its own sentence.
Okay.
The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. Mr. Brooks, when we get done here today, I think it's fair, since we've been here quite long. I don't intend to have a very lengthy discussion tomorrow, but I'll print all of these off for you so you can review them tonight. That'll also give you an opportunity to look at some of these topics, as well as if you want to draft your own instruction on some law. And then first thing tomorrow morning, we'll have a very brief discussion. It's only on these added the language, not the whole packet. The other parts of the packet have been approved by this court, but that'll give you an opportunity to further look at it. It's another long afternoon. It can be a little hard to follow these things, even when they're in front of you. As you can see, there are 68 pages of instructions. I think it's reasonable to have these all printed off and give Mr. Brooks and the state one more opportunity to review them for final consideration first thing in the morning.
Just so I understand. For the record, the jury instructions that you have are the ones that we're gonna use. I can't make a few of my own.
You can still, if you want to draft something, you have to submit it so that we can consider it, but it has to be in writing. And keep in mind, sir, jury instructions are read by the court, and they're statements of the law that I give to the jury so that they better understand their functions as a juror and the law that applies to this case. But you have until tomorrow morning to bring that to court in written form. If it's accepted by the court, my clerk will type it up and will insert it in the appropriate spot. If it's not accepted, then it won't be included. But as to what we specifically have before us today, not including the language that I just changed, so everything but the bail jumping, element 3, do you have any objection?
Yes, I do.
Okay? You have to give me a legal reason, sir, or are you just stating an objection that you don't consent, which I'll note for the record if that's the case.
Well, it's still the same that I said before.
Okay.
At this point, I don't see why. I guess essentially what I'm saying is if the issue was never raised before, and there's been ample time, at least for the prosecution, to review the questionnaires, or not the questionnaires, I'm sorry, the jury instructions. What prompted the change now, all of a sudden?
Because this is the time in the proceedings for the court to finalize those and to address any modifications. That's standard protocol.
So I'm still.
All right, your objection is noted, sir. I am approving everything that's in there. The parties will still have an opportunity to look at the change to the jury instruction on bail jumping. Mr. Brooks will still have an opportunity to submit any additional proposed instructions tomorrow morning, but at least we have this packet that's been approved, again, with the one exception on the bail jumping charge under element 3.
It has to be in writing, just so I understand. Everything's in writing.
It does have to be in writing, sir. That is a requirement.
So would that be in the form of a motion or just a simple writing? I don't understand.
Sir, you can simply submit proposed jury instruction, okay? But it does need to be in writing because that's how I will need to review it.
Yeah, I follow that part. I'm just, like I said, I'm just trying to understand what it needs to be written up as a motion or just a simple writing.
It can be a simple writing. You don't have to put a motion. I'm allowing you to submit a proposed jury instruction or instructions, I guess, if that's your choice. I don't know what you have in mind, but you can submit those tomorrow.
Yeah, I didn't have any. I just wanted simple clarification. That was all.
I appreciate you seeking that.
So.
All right. As to my list, other than the motion for reconsideration, did I overlook anything?
I don't know if you want to discuss exhibits, Your Honor, and I did want to say for the record, we did file what we have currently is 8 pages of exhibits, numbered 1 through 140. It's a combination of videos, photographs, and documents. I did have that 8-page list hand-delivered to Mr. Brooks earlier by Detective Reglin. That's one of the documents that he's stated he will decline to accept. However, it's an important document and one that he would be well-served to read. In addition to that, Your Honor, we've had all 140 of our exhibits saved to a thumb drive, and Detective Reglin hand-delivered that to Jail Administrator Wollenhoff this afternoon, so that if Mr. Brooks wants to look at our exhibits tonight, he can do so. He just has to ask the correctional officers for for that thumb drive with the exhibits on it, and he can see all 140 exhibits that we've prepared so far, and have a very good indication of some of the evidence that will be presented against him during the trial. Opening statements. I understand the court's order. You want us at our tables. Would the court reconsider that in the event Mr. Brooks is not present in this courtroom for the state's presentation of opening?
At this time, I would not reconsider because, as you know, I oftentimes invite him back in or require him to come back in, and I don't want to be in a situation where now I've let you do that, but I can't let him do that for what I think are obvious reasons to everyone.
Oh, I see. Okay.
So,
But we can stand up at our table during
You
openings.
can stand up, yes.
And he can too.
He can stand up as well.
Okay.
Yeah,
Okay.
but no podiums. I can address poster boards and physical evidence. I will make an exception to approaching witnesses for those types of things because it's a limited exception to my rule, and I wouldn't. How else would you be able to do that, right? I mean, the poster boards, you might have those electronically in some other format that you could use. You might want to use the annotation. Just for the record, Mr. Brooks is handing up the objection sign. We're just talking generally about procedure. There's no exhibit or to specifically object to. I'm not sure if you're objecting to procedure, but I'll get to that in a moment. Certainly physical evidence, you need to make certain, there needs to be certain foundational testimony. They're going to need to see those pieces of physical evidence. I understand that.
Okay.
Anything else?
No, that's it. Thank you.
Mr. Brooks? You raised an objection or?
Well, yeah, because I didn't want to have to try to write something and then have to send it over there. I really was raising it so you would know I wanted to say something, but still not interrupt. Just so I will understand, what the prosecution is saying by burning the exhibits onto the flash drive and then admitting them into the record. Is that then essentially when things will be admitted into evidence? Because I had that issue yesterday when I asked that question. Because I have exhibits too, and I have some things that I would like to offer into evidence as well.
So I'm not talking about like admitting things with specificity at this moment. I'm talking about some procedures. I'm trying to frankly be mindful that you're in custody, sir, and that even though when you appear before the jury, you're dressed in civilian clothing, like the suit that you wore the other day, but I am taking steps to ensure they don't see the restraints that are on your ankles. And because you have that physical limitation, I now am adding or have added a limitation to the state on, for the most part, physical movement within this courtroom. That's why there's no podium. They're not going to make opening statements or closing arguments from a podium. It's really to, in my words, level the playing field, if you will, and to ensure that as the parties appear before the jury, it's on as level of a playing field as I can provide. So if you have documents, we have a thing called a document camera, and so it will be in use. It may require the assistance of the bailiff because my understanding is, and we can talk internally to find out if I need to have court staff, whatever. My understanding is it has to be on the state's table. I'm not sure where it went. It's usually been there. And so it's possible, we'll find it. It's possible. Okay, it's been moved. We'll put it back, but it has to go on the state's table. So if you have a document, sir, it might require you to pass it to someone who then puts it under the document camera, and assuming the witness, it's appropriate, meets the rules of evidence, it can be authenticated, there's a proper foundation, etc. And if I receive it, once you hear the phrase, the exhibit's received by the court, that's when it becomes an exhibit that the jury then can use. Does that answer your question?
Not really. I think, I'm sorry, Your Honor.
That's okay.
I think what I was referring to more as,
for things to be able to be offered into evidence. So was that answering that? If it was, I apologize. I don't
Do you have the exhibits? Are they paper? Are they electronic? Are they something else?
Well, I'm sure the majority of them would be papers.
So sometimes there's something in the discovery that's electronic that a defendant wants to use at trial. And I have typically asked the state for assistance because they have all of that. At least that would be my understanding. If there's something specific, though, and they have it, you should let them know. I don't need to be involved in that conversation per se, but you could write out for them what it is. And then I'm sure they can make arrangements to display it. And so it's presented to a witness if appropriate. Go ahead.
Would I write that out? Would that be like an in-court thing? Because that's obviously the only time I would see the prosecution.
Well, sure. You would write it while you're in your cell, when you're in the conference room reviewing things, and just make some notes on what it is. And then tomorrow morning or whatever day of trial, if you think you're going to want something and it's not on their exhibit list, you just make a note and we'll see if they cannot make arrangements during the trial to display that. I'm not speaking on whether anything's admissible at this point or not. I'm just talking procedure.
Okay. I'm not sure about that. Well, the statement or the sentence before the last one with the exhibits, they have to be separate exhibits. The prosecution has their own exhibits and I have my own, so that way we're not using each other's exhibits. At least that's what I took from.
Yes, but if you're going to use an exhibit that the state's right, if they have something on an exhibit list that you want to use, it's pretty standard that we only use one copy of whatever it is, and then you're able to use that once during your case because it's already been admitted. Hopefully that helps answer your question.
Yeah, that helps.
Okay. Anything else?
No, we did want to indicate that certainly we're willing to share exhibits with Mr. Brooks. If there's anything he wants displayed and it's admitted by the court, we can pull it up and be of assistance to the court and Mr. Brooks. We also want to renew our earlier offer if he needs assistance in serving subpoenas, as long as it's a relevant witness and it's a reasonable request that is limited to southeastern Wisconsin. We will give any assistance we can. We want Mr. Brooks to have a fair trial. We want him to have his relevant witnesses and evidence ready for the court. If there's something he wants, even if it's a document, we don't have the document camera, we have the entire file scanned, or he can give it to us and we can scan it in 1 minute and have it up on the screen. So we are more than willing to do that so that we can all be efficient in our presentation.
Thank you. Did you hear that, Mr. Brooks?
Yes.
All right. So if there are things that you
say too, I'm sorry.
No, go ahead.
I was going to suggest that at some point, I didn't know if I'd be able to get to it today, but now it came up. That's one thing about the subpoenas.
So the sooner you can fill those out and get them to, I can copy them for you so that the state has them and give you a copy. We'll facilitate that, right? I know you're going to want to keep a copy of whatever it is, but the sooner you can bring that information to court, that would be the easiest and most efficient way to get that information to the state, meaning you got to fill out your subpoena forms and then give them to the state, who will then look at them and they'll be able to tell you yes, no, and we'll go from there, okay?
So I'm not asking for legal advice, but it would greatly benefit me if I'm able to know that I am filling out the subpoenas correctly.
I'm able to review for completeness. So if you bring them to court I can at least do that.
Okay, because the last thing I want to do is write all these subpoenas up and then bring them in and they're incorrect, or something is not done the way it should be done, and then
I can review for completeness, and we can go from there.
And Your Honor, I just wanted to correct one statement I made before. I had indicated that the jury instructions would be available on the computer in the conference room. That is not correct. They would be available in Lexis, which I believe is on his tablets.
Do you have Lexis on the tablet?
I'm sure I can find it. I wanted to say too, it's not my tablet. They're for use from everybody, so I don't have my own specific tablet.
Understood. Lexis is a legal research, legal material platform. It's actually what I use, so I know it to be very thorough, but you have to search for things, but I'm told that the jury instructions are available through Lexis through the tablet.
Yeah, I don't know exactly what the program is called itself. It just goes by the law library. That's what we all
Okay.
call it. So.
All right. Is there anything else, Mr. Brooks?
No.
Okay, then that leaves tomorrow morning just the finalization of the jury instructions and the motion for reconsideration.
Yes.
Okay, all right. Thank you, everyone. We are in recess for tonight. We'll see everyone tomorrow at 8:30 a.m.
You could let him know I'm gonna print it right now, so it can be handed to him before.
Yep, and the bailiffs need to make sure they don't let, we need to print off material for him. It's coming forthwith. All right, thank you. We're in recess.
Can you imagine what these people must be thinking? Dealing with Darrell Brooks is the most tedious thing a person can do. But I'd still like to believe that if a person is as dumb as Darrell Brooks is, that they could still win a trial as their own attorney, as long as the facts are on their side. And that's Darrell Brooks' biggest problem. The facts are simply not on his side. And his only real defense seems to be, I do not identify by that name. But with the end of this day of court proceedings, this actually concludes our little pre-trial trilogy. And from here we go back to day one of the jury trial. And if you've made it this far into the video, I certainly appreciate it. Thanks for watching, and I'll see you next time.
And I want to say one thing to your children. I know some really great ice cream places around here. And Daddy owes you. Okay? So talk to me afterwards.